Mabuhay! Good day, everyone. So for today's discussion, it's all about criminal law. Firstly, the Revised Penal Code or Act Number 3815 is the source of criminal law that is composed of Book 1 and 2. Book 1 tells the general provisions regarding the date of enforcement and application of the provisions of this code, and regarding the offenses, the person liable, and the penalties. Book 2 is all about the crime and penalties. So what should we know about criminal law? How do we know something is a crime? So first, what is criminal law? As stated, criminal law is the body of law that relates to crime. It regulates social conduct and prescribes whatever is threatening, harmful, or otherwise endangering the property, health, safety, and moral welfare of people. It includes the punishment of people who violate these laws. So criminal law varies according to the jurisdiction and differs from civil law, where emphasis is more on dispute resolution and victim compensation than on punishment. In addition to that, civil code has criminal aspect liability when it comes to damages or injuries. Again, criminal law is a branch of public law, treats of their nature, and provides for their punishment. In some cases, a particular act may be both a civil wrong as well as crime. For example, the act of assaulting someone can be both civil, one could sue for damages, and also a crime. However, the difference between a civil claim and one that is criminal in nature is that a criminal case is an action between the state and a private party. So, what we focus on? We have first basic and major principles of criminal law, which I will discuss later on. Second, sexual harassment under the crimes against chastity. And third, illegal recruitment under the crimes against public interest, which will be discussed by the other members. Basic principles of criminal law. First, general or generality means the law is binding to all persons who reside in the Philippines. Second, territorial means the law is binding to all crimes committed within the national territory of the Philippines, which means that the venue, whether municipal or international, is jurisdictional. We have the three under the territorial, terrestrial, jurisdiction exercise over land, fluvial over maritime or interior waters, and third is aerial over the atmosphere. 3. Prospective or prospectivity means the law does not have any retroactive effect unless favorable to the accused. Let's go to the major principles of criminal law system. It is when it comes to hearing, it has also due process of law. First, a person is presumed innocent until proven guilty. This is right given by a law and guaranteed by our Constitution that any person charged into a particular crime or offense must be first proclaimed to be innocent and until such time be proven his or her guilt under the principles of presumption of innocence. Second, a person's guilt must be proven beyond reasonable doubt. This is in the course of a trial proper. The court proceeds its investigation to the case with the assistance of both counsel and the prosecution and the defense to establish ascertaining the truth of the matter of the fact, the evidence proving the guilt or innocence of such person accused. And it says also that in case of doubt, the doubt must be presumed in favor of the accused. Third, no person can be required to incriminate himself or herself. This is a provision against self-incrimination. Our law protects the people from this kind of act because it will entail danger to the lives or life of any such innocent persons. Fourth, a person who has been acquitted cannot be tried again for the same offense. Why? Because it is against the principle of double jeopardy. In jurisprudence, double jeopardy is a procedural defense that prevents an accused person from being tried again on the same or similar charges following an acquittal or conviction, and in rare cases, prosecutorial and or judge misconduct in the same jurisdiction.
Now we will discuss sexual harassment. Sexual harassment is defined as any demand, request, or requirement for a sexual favor, regardless if it is accepted or not, made by any person who has authority, influence, or moral ascendancy over another in work, training, or educational environment. Sexual harassment is an illegal act that constitutes unwanted conduct of a sexual nature. The act can be offensive can include commenting about a person's physical characteristics, inappropriate sexual charged languages when talking to an individual or another person, the discussion or speculation of the sexual orientation of another person, any unwanted solicitation for dates or intercourse, any form of physical contact that make another person uncomfortable, any displays or deliveries of materials of a sexual nature, including inappropriate pictures or video, and any punitive behaviors designed to humiliate or punish a worker or individual who finds any approach of a sexual nature unwelcome. Sexual harassment is an illegal act, and it can become a crime once it violates criminal law, or once it involves stalking, assault, or rape. Harassment can be physical, emotional, or verbal form. In physical harassment, it can include malicious touching, overt sexual advances, and gesture with lewd insinuation. Verbal, such as or not limited to requesting or demanding sexual favors or saying unwelcome remarks, or use of objects like pictures or graphics, letters or written notes with sexual underpinnings, and other form analogous to the foregoing. Typically, this action takes place in school or work environment or elsewhere. Due to increasing cases of harassment, the Anti-Sexual Harassment Act of 1997 or Republic Act 7877 was created. This act declares sexual harassment unlawful in the employment, education, or training environment and for other purposes. It was enacted on February 14, 1995 and became effective on March 5, 1995, 15 days after its publication on MARIAH and Times Journal on February 18, 1995. Under Republic Act 7877, the employer or head of office is required by the law to prevent the occurrence of sexual harassment acts and to provide procedures for the resolution, settlement, or prosecution of the sexual harassment.
And for its classification, sexual harassment is classified as grave offenses wherein it is the unwanted touching of private parts of the body such as buttocks or breast, or someone is requesting for sexual favor in exchange for employment, promotion, local or foreign travels. Next is less grave offenses. Under this is unwanted touching or brushing against a victim's body, though pinching is not falling under grave offenses. And third is light offenses, or looking or stealing a look at a person's private part or worn undergarments, or even telling sexist or smutty jokes or sending this through text, electronic mail, or other similar means, causing embarrassment or offense, and carried out after the offender has been advised that they are offensive or embarrassing. Even without such advice, when they are by their nature clearly embarrassing, offensive, or vulgar. Of course, there are penalties for offenses of sexual harassment. For grave offenses is dismissal. For less grave offenses, we have first offense and second offense. First offense or fine offense or suspension for 30 days but not exceeding 6 months. And for second offense or dismissal. While for the light offenses, we have first, second, and third offense. First offense is reprimand. Second offense is fine or suspension, not exceeding 30 days. And third offense is dismissal. Moreover, any complaint for sexual harassment properly filed against any employee in that office shall be charged with neglect of duty, and any person found guilty of sexual harassment shall, after the investigation, be meted the penalty corresponding to the gravity of the offense. Sexual victims may also file a civil action for damages against the perpetrator, and the law also requires all government and private offices, schools, and other institutions to establish procedures for the investigation of sexual harassment complaints and to provide mechanisms for the protection of victims. For example, a hotel staff member is making inappropriate comments or gestures towards a female guest. The guest may feel uncomfortable and unsafe in the hotel and may decide to cut short her stay or never return to the hotel again. And in order to prevent such incidents from occurring, the hotel can establish policies and procedures for preventing and reporting incidents of sexual harassment. This can include providing training and education to employees on what constitutes sexual harassment and how to prevent it from occurring. Second, they can create a clear reporting mechanism for guests who experience sexual harassment, such as a hotline or designated contact person. Third is enforcing a zero tolerance policy for sexual harassment and making it clear to employees that any incidents of sexual harassment will be investigated and dealt with seriously. And if an incident of sexual harassment does occur, the hotel can take the following steps to address the situation. First is to provide support and assistance to the guests who experience the sexual harassment, such as offering to move them to a different room or providing them with a safe space to rest and recover. Second is investigate the incident thoroughly and take appropriate action against the employee who committed the harassment, such as termination of employment or reprimand. Third is follow up with the guests to ensure that they feel safe and comfortable in the hotel, and to offer any additional support or assistance if needed. By taking proactive steps to prevent sexual harassment and addressing incidents that do occur, hotels can create a safer and more welcoming environment for their guests. We also have the Safe Spaces Act, also known as the Bawal Bastos Law. It is a law in the Philippines that aims to prevent gender-based sexual harassment in public places. Under the Safe Spaces Act, all public spaces are required to have a clear policies and protocols in places to prevent gender-based sexual harassment. These policies include the posting of visible signage that clearly states that gender-based sexual harassment is prohibited, the establishment of complaint mechanism, and the provision of gender-sensitive training to employees. The law defines gender-based sexual harassment as any unwanted and uninvited sexual actions or remarks against any person, regardless of their sexual orientation, gender identity, or expression. These can include unwelcome touching, making sexual gestures or comments, and other verbal or non-verbal conduct of a sexual nature. The law provides penalties for violators, including fines, imprisonment, mandatory community service, and gender sensitivity training. The law seeks to create a safer and more respectful public spaces for all individuals, particularly women and members of the LGBT community, and help prevent gender-based violence and harassment. By holding perpetrators accountable for their actions and promoting a culture of respect and safety, the law seeks to help prevent gender-based violence and harassment.
Good day, everyone. We are now going to discuss about illegal recruitment. A lot of us are getting victimized and a lot are involved in this. It is deemed committed by a syndicate if carried out by a group of 3 or more persons conspiring or confederating with one another. Moreover, what really is illegal recruitment? According to the Republic Act of 8042, it shall mean any act of canvassing, enlisting, contracting, transporting, utilizing, hiring, or procuring workers and includes referring, contract services, promising or advertising for employment abroad, whether for profit or not, when undertaken by a non-licensed or non-holder of authority. There are several cases of that here in the Philippines. Some of us are getting lured, of course, because of money. You can hear some cases that sadly ended up with forced labor trafficking case. There are two types of illegal recruitment. First is the simple illegal recruitment. It is when the offender has no valid license or authority required by law to enable him to lawfully engage in the recruitment and placement of workers. In 2010, RA 10022 increased the penalty for simple illegal recruitment to 12 years and 1 day to 20 years imprisonment and a fine ranging from 1 million to 2 million pesos. The second one is the illegal recruitment as economic sabotage. It is considered as economic sabotage if it is carried out by a group of 3 or more persons conspiring or confederating with one another, or it is committed against the 3 or more persons individually or as a group. To simply explain this, illegal recruitment when committed by a syndicate or in a large scale shall be considered as offense involving economic sabotage. It is now life imprisonment and fine ranging from 2 million to 5 million pesos. Lastly, the penalties under this are stated in the Republic Act number 10022. It states that any person found guilty of illegal recruitment shall suffer the penalty of imprisonment of not less than 12 years and 1 day, but not more than 20 years, and a fine of not less than 1 million pesos nor more than 2 million pesos.
Number 1 is legal consequences. You can discuss the legal consequences of engaging in illegal recruitment, including the potential penalties, fines, and sanctions that can be imposed on individuals or organizations found guilty of illegal recruitment. This may include civil and criminal liabilities, administrative sanctions, and imprisonment. The second part is victims' rights and protection. You can talk about the rights of victims of illegal recruitment, including their entitlement to protection under the law, access to justice, and remedies available to them. This may include discussing the role of government agencies, non-governmental organizations or NGOs, and other support mechanisms in assisting victims of illegal recruitment. It is also crucial to note that illegal recruitment is a serious offense, an unethical activity that is against the law in most countries. It's most important to comply with the law and prioritize the rights and protection of victims, take preventive measures, and uphold ethical recruitment practices to prevent and combat illegal recruitment. The third one is preventive measures. You can discuss the preventive measures and best practices that individuals, employers, and authorities can implement to combat illegal recruitment. This may include raising awareness among potential job seekers about the risk of illegal recruitment, conducting thorough background checks on job offers, verifying the legitimacy of recruitment agencies or employers, and reporting suspected cases of illegal recruitment to the appropriate authorities. Lastly is ethical considerations. You can discuss the ethical implications of illegal recruitment, including the exploitation and abuse of vulnerable individuals, the impact on labor markets and economies, and the violation of human rights. This may involve exploring the moral and social responsibilities of individuals and organizations in ensuring fair and legal recruitment practices. A key point to remember: it is important to note that if you suspect any illegal recruitment activities, you should report it to the relevant authorities immediately. It is always best to comply with the law and promote fair and ethical employment practices.
That's it for the criminal law. We hope that you have learned something from our report. Thank you.